If you live in Oregon and are going through a divorce, you may want to know what happens to your home or other property. I'm Hansery LaForest, the Oregon Family Law Guide, here to present to you 4 basic things you should know about Oregon divorce and distributing the house. Keep in mind, this is not legal advice. Distributing a home and other property in a divorce is done through court proceedings and court orders, and it can get really complex. So if you need legal advice for your specific situation, stop and consult with an attorney. These are just helpful guideposts to help you understand what goes into how a court decides what to do with the house or home during a divorce. With all that said, let's explore 4 basic things you should know about Oregon divorce and distributing the house. The first basic thing you should know is that the equity, or the market value after debts, in your home will likely be considered a marital asset to be distributed on divorce. Let's break that down. For all property of either spouse or both spouses, before the marriage or after, a court must determine what division is just and proper. They call this equitable distribution. In an Oregon divorce, how the court makes this distribution depends on whether the property belongs to one of 2 categories. The first category is marital assets, which is property specifically acquired during the marriage. The second category is marital property, which is all other property. That includes property you got before the marriage, gifts to a specific spouse only, or an inheritance that goes to a specific spouse only. For marital assets, courts presume that both spouses contributed equally to that marital asset. This means that a court may divide the property equally between both parties. What if one spouse is a homemaker or stay-at-home spouse? Or what if one spouse didn't purchase that asset? The court still presumes both contributed equally and may be entitled to an equal division. Now, you can defeat this presumption. You can demonstrate that the other spouse didn't contribute equally, or that one spouse contributed disproportionately more than the other spouse. But if that presumption of equal contribution isn't rebutted, a court may likely divide the property that falls under this marital asset umbrella equally. On the other hand, for marital property, or all other property that doesn't fall under the marital asset umbrella, a court doesn't presume both spouses contributed equally. Instead, using a variety of different factors, the court's just and proper division may be equal division or awarding a spouse an asset outright. Where does a house fall in all of this? Well, for a house may be acquired during a marriage. That house would fall under the marital asset umbrella, meaning that the court would presume both spouses contributed equally and should be entitled to an equal division. But what if the house was acquired by one spouse before the marriage? No equal division, right? Think again. The appreciation or increase in value of that house during the marriage will likely fall under the marital asset umbrella and would be entitled to equal division. The second basic thing you should know is that your debt on the house can also be distributed equally. Generally, when courts are evaluating the equity of the house for equitable distribution, they do this by taking the fair market value of the house and subtracting any debts on the house. Generally, fair market value means the amount for which a house can be sold for on the market. The fair market value of a house can be calculated by hiring an expert, such as a real estate expert, to offer an assessment and appraisal of the home. On the other hand, the debts on a house include mortgages, loans, any liens, and taxes. When the outstanding debts are subtracted from the fair market value, that balance is the equity and is what the court then considers in making an equitable distribution. The third basic thing you should know is that courts don't necessarily have to award one spouse a house over the other. After a court calculates the equity in the house, there are a number of ways to distribute that equity. One way is for the court to order the sale of the home and for the proceeds to then be divided amongst the spouses. Another way is for the spouses to refinance the home and to purchase the other party's share of the home. Another way is for one spouse to remain in the home with exclusive use and possession for a set time. After that set time, the spouses can then sell the house and divide the proceeds, or one spouse can then buy the other party's share to keep that house. That leads us to our fourth basic thing that you should know. The fourth basic thing you should know is that if the house is the family home and the spouses have minor children, the spouse with custody of those children may end up keeping the home. Here's why. Courts generally prefer not to require the sale of a family home while a parent with custody and minor children live in it. When the spouse with custody doesn't earn as much as the spouse without custody, the court may be inclined to permit the spouse with custody to remain in the house for a time. Often, the court will allow the spouse with custody of the minor children to stay in the house until the child or children turn 18 or leave for college. After that happens, the court may then allow the house to be sold and the proceeds to be distributed equally, or for one party to buy the other party's share of the house. And that's it. 4 basic things you should know about Oregon divorce and distributing the house or home. If you have further questions or need additional information, feel free to follow the link listed below. Thank you.